attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about finder's fees. Section 15A1 of the Securities Exchange Act requires any broker that makes use of the mails or any means or instrumentality of interstate commerce to effect any transactions in or to induce or attempt to induce the purchase of or sale of any security other than any exempted security to register with the SEC. The text of Section 15A1, entitled Registration of All Persons Utilizing Exchange Facilities to Effect Transactions, is as follows. Section 15A1. It shall be unlawful for any broker or dealer which is either a person other than a natural person or a natural person not associated with a broker or dealer, which is a person other than a natural person, other than such a broker or dealer whose business is exclusively intrastate and does not make use of any facility of a national securities exchange, to make use of the mails or any means or instrumentality of interstate commerce to effect any transactions in or to induce or attempt to induce the purchase or sale of any security other than an exempted security or commercial paper, banker's acceptances, or commercial bills, unless such broker or dealer is registered in accordance with subsection B of this section. In other words, anybody who brokers securities transactions in a national exchange, other than ones that work solely within a state, do not use national mails or national exchanges, must be registered on a national level. Section A4A of the Exchange Act defines a broker as any person engaged in the business of effecting transactions in securities for the account of others. From a legal perspective, determining whether a person must be registered requires an analysis of what it means to effect any transactions in and to induce or attempt to induce the purchase or sale of any security. It is precisely these two phrases that courts and commentators have attempted to flesh out with inconsistent and uncertain results. As a securities attorney, I always advise to err on the conservative side where the activity is at all questionable. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.